If you think that the executive branch or the legislative branch is going to protect your rights, you got another thought coming.
The majority can take care of itself. But what the judiciary has to do is to make sure to protect the individual rights of the minority.
And of course, the subsidiary goal is to assure that we have a system in place that will produce the kinds of judges that are fair, that are impartial, that are not beholden to any group, that are neutral in order to achieve this kind of protection.
Let's say, for example, that I was on the Supreme Court back then. For me to be reelected, someone could run against me. I would run against a person, and I would have to raise money to run a statewide election, like the governor has to, like the Attorney General and the other cabinet officers. They have to run a statewide election. So I would have to raise that kind of money for me to be able to put up a campaign against anyone who runs against me. And that led to some really less than ethical practices in this court back then.
Between 1968 and 1970, 5 new justices joined that 7-member court. And every one of them was chosen in one way or another because of politics, not necessarily merit. And every one of them brought a problem with them, or a set of problems with them. One of them, Joe Boyd of Miami, was a career politician who had absolutely no credentials in appellate law and could never have gotten an interview with the nominating commission, had there been one. David McCain, who was appointed to a vacancy created by death, was appointed by Governor Claude Kirk despite strenuous opposition from the Florida bar, which regarded McCain's conduct as a district court judge as unethical. And McCain ultimately wound up to be the only ex-justice disbarred for his conduct on the bench. There was a 5th justice, probably was an experienced circuit judge who probably would have qualified for a nomination, but he brought political instincts to the court. That particular judge tried to sway a circuit court case, lobbied a circuit court judge on behalf of a campaign supporter from Miami. And a rampant case fixing by 2 judges on that court, 2 justices.
I wanted to just take it out of the hands, uncontrolled hands of governors, because we've had some that we had a whole history of good judges for the most part, you know, until the 70s, and it reflected this business of trying to, you know, pick how you go about picking judges. And I just really felt like that I wanted to take it out of the hands of politics to the extent one can. I didn't want to make my decisions based on ideology. I think that once it showed that I was sincere in trying to remove a lot of power from me, I wasn't that interested in it. What I was interested in was to improve the judicial system.
Historically, there really were there was no opposition that had been lodged against a judge for a merit retention campaign until the campaign of Justice Ehrlich and Justice Shaw, if I'm remembering correctly.
These are Supreme Court justices?
They were Supreme Court justices. They were both on the court before I was on the court. And an initiative had been proposed to make an amendment to the Constitution having to do with taxation. I don't remember exactly the details of it, but the group that was moving for the amendment was upset because the court had ruled that the amendment wasn't an appropriate form and had not permitted it on the ballot. And they challenged Justice Shaw and Justice Ehrlich on the basis of this, taxation amendment. And both Justice Shaw and Justice Ehrlich together had to campaign across the state, seek funds from lawyers, run a campaign in order to retain, to both educate the public who didn't really understand retention campaigns, and then to be retained. They successfully weathered that merit retention campaign. In my case, it was clear that a group announced that they intended to challenge. It was a group that were upset with the decision that invalidated the parental consent for abortion. This is my speculation. I believe it to be correct. Because they did not succeed in Justice Shaw's case by just targeting that abortion issue, the same group expanded and attempted this soft on crime campaign as an ancillary. One of the other justices on the panel had also signed on to Justice Shaw's opinion on abortion and wasn't challenged. So I think there are overtones of race and gender that occur. So a judge in that position who has not been a politician is faced with this whole overwhelming concept of, oh my gosh, I've got to run a campaign. What do I do? How do I go about it?
Traditionally, they hadn't paid much attention to it, but because of the importance of the decisions that we render in the court, special interests know that it's easier to elect 7 judges than, 200 state legislators? We were aware of it, and we tried to make people aware informally, but we didn't mount an official campaign. We didn't raise any money. I talked with the media about it when asked, and to try to, basically I told them we were like sitting ducks.
I just find the whole idea of judges raising money to be very distasteful. When people give you money, regardless of the intentions, somewhere in the back of their minds, there's just this whole idea that, we want something. We want you to rule in a certain way.
Also opposed patients' rights, undermined property rights, education, and fair election. Florida has one of America's most activist courts.
Voted to put an amendment on the ballot to let Florida voters decide. But then the Florida Supreme Court removed the amendment from the ballot, denying us a voice and a vote.
And so we had a concern as a bar that since that had happened in their retention election, and knowing that we had another retention election in 2012, that there was a potential that could happen again, and we had to think about what, as a bar, should we do. That was done against the backdrop of what we could see was happening in other places.
2012, we wound up with another attack against 3 justices, and happily they were prepared for it and did allow people to go out and raise money for them. I think they were quite careful not to raise money themselves, but they certainly did not try to prohibit campaigns being conducted in their behalf. And I think, again, they came to this conclusion from some of the history of what was happening around the country.
One of the issues that was raised in this campaign was whether or not we were going to let someone who had committed a murder go free. Well, that was never really the issue, but that's the kind of thing that really makes the public want to sit up and take notice. The issue was whether or not the person had had an effective assistance of counsel, and if not, was he entitled to a new trial. Not whether or not he was going to be let free, but it was turned around into letting someone off who had committed a murder. And those are the kinds of things that I think do just an injustice to the system because of misinformation.
I was also frustrated by the very idea that people had to raise money on our behalf, but maybe I'm getting ahead of myself. I find the idea that we are not politicians, yet we're having people raise money and having to do some of the things that an elected official would do shows that there is an inherent tension that was probably not anticipated at the time that merit retention was adopted about how do you stay true to who you are as a jurist, yet not allow a group of special interest to run over the judicial branch by attempting to make it a political branch.
Then as time went on, the internet started carrying and organized groups within certain partisan political parties started circulating emails. And I received copies of emails from my friends describing me as they were sharing with me what was going on, sharing with me the terrible things that were being said across the internet, and that they were asking their political allies to pass this on to as many people as they could. So we were under attack.
You probably do feel somewhat of a sitting duck because there are limitations on what you can do. There are limitations on what you can say. There are limitations on fundraising. And so you do, and you don't have any specific person that you are opposing. It's more, I'm not even sure how you term it, ideology maybe? And so it does make you somewhat uncomfortable.
I never thought about giving up, and the worse the attacks came, the more I realized how important it was for us to be doing what we were doing, because my feeling was I wasn't doing this for myself. As I mentioned, my career had been long and successful, both as from law school on. I am very proud of my professional accomplishments, and I could easily have retired. But my concern is that if I left and my fellow justices left, just gave up, we would not just embolden our opponents this time against us, but that the trend would be set.
I carried around in my stomach a rock for a 2-year period because I care about the system. Not so much me personally, but I want this system to survive long after I'm gone, because I believe in a system that strives to eliminate partisan politics from its control.